Welcome to Tomkins Talks. It's time for a summary of another recent case in a short, snappy way that's easy to digest, whether you're at home, in the office, or on the move. Now, back in October 2020, I talked about the case of Capitol Park Leeds Plc and Global Radio Services. Well, this case has now gone to the Court of Appeal and judgment was handed down on the 5th of July 2021. Before we get to the judgment, let's take a step back and start with the backstory. When a tenant exercises a right to break a lease, it must strictly comply with the conditions attached to the break. As in sport, and as Thomas Muller can attest, there are no prizes for coming close. A condition frequently attached to a break is that a tenant must yield up with vacant possession. In order to satisfy this condition, generally speaking, a tenant needs to ensure it gets over two hurdles on the break date. First, it must not be using or occupying the property, and second, there must be no substantial impediment to the landlord using or occupying the property or a substantial part of them on the break date. Now, this case concerned a property on Capitol Park in Tingley, Leeds. The tenant, Global Radio, had a lease for a term of years expiring in 2025, but including the right to break on the 12th of November 2017. Global had to comply with a number of conditions in order for the lease to end on the break date, including one to give vacant possession of the premises to the landlord. Global served a break notice in February 2017 and prior to the break date carried out various works to the premises to seek to mitigate its potential dilapidations liability. It removed various items from the premises, including ceiling grids, radiators and emergency lighting. Now, there were various discussions between the parties' representatives prior to the break date as to the works carried out by the tenant. In short, the tenant ceased carrying out works to try and agree a negotiated settlement with the landlord, but that was never concluded. And by the time negotiations ceased, there was not sufficient time for the tenant to complete its proposed works. So it handed the property back to the landlord on the break date, with various items having been removed and not replaced. The landlord asserted the tenant had failed to give vacant possession of the premises on the break date. It pointed to the definition of the premises in the lease, which included the existing building when the lease was granted, and all fixtures and fittings at the premises were never fixed, except tenant's fixtures. The tenant responded by arguing that a requirement to give vacant possession did not require an assessment of the physical condition of the demised premises. So what was the outcome? The High Court judge was satisfied that the tenant failed to give vacant possession of the premises to the landlord. He came to this conclusion on the basis that the premises, as defined in the lease, included fixtures and fittings, and by effectively handing back an empty shell of a building to the landlord, the judge said that the premises were dysfunctional and unoccupiable. As such, there was a substantial impediment to the use of the building by the landlord. However, the Court of Appeal has taken an alternative view. Lord Justice Newey, who gave the leading judgment, held that a requirement to give vacant possession refers to giving the property back free of people, chattels and interest, but there was no regard to its physical condition. He concluded his judgment by saying this: "In all the circumstances, it seems to me that construing it in the context of the lease as a whole, clause 10.1.4 requires the tenant to return the premises as they are on the break date, free of the trilogy of people, chattels and interests. On that basis, Global's exercise of the break clause was effective and the lease terminated on 12 November 2017. True, it may be that the building was left in a dire state, as Miss Wicks said, that was the landlord's counsel, but that will not have precluded valid exercise of the break clause. Capital's remedy, so the landlord's remedy, is to seek compensation for whatever loss it may have suffered." And he went on to allow the appeal on that basis. So what does this mean? Well, it's clearly good news for tenants and does provide welcome clarity on a requirement to comply with a break condition to give vacant possession. However, tenants will be well advised to still very carefully consider the wording of break conditions they will need to comply with, given the requirement to comply with them strictly. I hope you found this useful. Please comment, like or share the video if you have. I'll see you soon for another Tomkins Talks.